Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are heavily caffeinated because today we are going to study Section 7 of the Companies Act 2013. Till now, we have completed Chapter 1, which consisted of Section 1 and Section 2, and we have also covered Section 3, 4, 5, and 6 of Chapter 2, which deals with incorporation of a company. In this video, we are going to tackle Section 7, which provides for the procedure that has to be followed for the incorporation of a company. This is a very important section from a practical point of view because all the provisions of Companies Act 2013 will only be applicable once the proposed company is incorporated. Therefore, one should have a thorough understanding of how a company is registered. Additionally, it is one of the most frequently asked questions in law firm job interviews that what are the steps required to incorporate a company, or what is the procedure which has to be followed for the incorporation of a company. And then you will be asked more related questions to test your clarity on the subject of company law. So, we advise you to prepare your answers well in advance and make sure that you have absolute clarity on this topic. Your answer and the way you present your answer would play a big role in getting that coveted job. Also, these are one of the simpler questions that you are asked during the start of the interview, which lays down the foundation for the next round of questions. Generally, the level of difficulty of the questions keep on increasing until you end up giving wrong answers or unsatisfactory answers in terms of quality and structure. So it's important to start strong. Having said that, it doesn't mean that you will lose out if you don't answer well in the beginning. It all depends on how you handle the situation and make a comeback. It doesn't matter that you answer all the questions correctly, but what matters is how you arrive to the conclusion or think about it and express yourself, even when you don't know the absolute answer. You're not expected to know everything, but we advise that your preparation should be good enough to answer the technical questions and answer with at least 70% accuracy. So, without further ado, let's begin. Section 7 subsection 1 says, "They shall be filed with the registrar within whose jurisdiction the registered office of a company is proposed to be situated the following documents and information for registration, namely." So, subsection 1 essentially provides with all the documents and information which have to be filed for the incorporation of a proposed company, that is, what all documents, forms and information would have to be submitted by a person who intends to incorporate a proposed company. It is important to note that we are using the term proposed company and not the term company itself because the company hasn't come into existence yet, and therefore we refer to it as a proposed company which will become a company after its registration or incorporation. Secondly, subsection 1 states that such documents and information has to be filed with the ROC, that is, Registrar of Companies, within whose jurisdiction the registered office of the company is proposed to be situated. For instance, if the registered office of the proposed company is situated in Delhi, then the concerned person would have to submit the relevant documents with ROC Delhi. Now, subsection 1 has 7 clauses which basically states all the documents and information that have to be filed with the ROC, which includes, as per clause A, the memorandum of association and articles of association which have to be duly signed by all the subscribers to the memorandum. So, as we've already seen in the previous videos while discussing Section 4 and Section 5, that MOA and AOA are the charter documents of the company and which have to be prepared and submitted to the ROC as the first step of the incorporation of the proposed company. The same point is being reiterated in Clause A. Next up is Clause B, which says a declaration has to be given by an advocate, a chartered accountant, cost accountant or company secretary in practice who is engaged in the formation of the proposed company and by person named in the articles as the director, manager or secretary of the company, that all the requirements of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with. So, Clause B basically states that an undertaking of sorts or declaration has to be given by all the professionals who are engaged in the incorporation of the proposed company, that all the requirements and prerequisites under the Companies Act 2013 and the allied rules in respect of the incorporation of the company have been complied with. As per Clause C, there's another declaration that has to be given by the subscribers to the memorandum of association of the proposed company and the directors, if appointed as per the articles of association, that such persons are not convicted of any offences in connection with the promotion, incorporation or management of the company under the Companies Act 2013 or any previous company law during the preceding 5 years, and that all the documents that they are filing are correct and true to the best of their knowledge and belief. Basically, Clause C requires a declaration from the subscribers to the Articles of Association of the proposed company, as well as the first directors of the proposed company, that if their names are mentioned in the Articles of Association, then they are required to give a declaration to such effect as is mentioned above. The main intention of this clause is to prohibit fraudulent persons, as well as persons who have already been convicted of any offense, from incorporating a company. For instance, if a director is disqualified due to any of the grounds as given under section 164, subsection 2, then such a director would be prohibited from acting as a director for a period of 5 years. This clause becomes important in ensuring that a director who is disqualified under the law does not get reinstituted as a director of another company. This is one such example. Here's a small exercise for you guys. Hit us up in the comment section with any case laws and the ratio given in the judgment regarding the disqualification of directors under section 164 of the Companies Act 2013, or any other example that you can quote in context of this clause based on your understanding. There was a notable judgment given by the High Court in Mukut Pathak versus Union of India in November 2019 relating to disqualification of directors under section 164, which is quite important. Why don't you guys give that a read too and send us a write-up on it, summarizing the judgment with facts, issues discussed, ratio, and the final judgment along with your own inputs on the said case at our email ID thecaffeinatedcorporatelawyer@gmail.com. Moving on. As per clause D, the address for correspondence is to be filed with the ROC till the time the registered office of the proposed company isn't established. As per clause Z, all the information regarding the subscribers to the Memorandum of Association has to be filed with the ROC, including their names, residential address, nationality, proof of identity, etc. And if the subscriber to the company is a body corporate, then such information about the body corporate also needs to be filed as may be prescribed. Don't forget, a body corporate being a separate legal entity can also hold shares in another company or become a subscriber to the Memorandum of Association of another company. As per clause F, the persons who are named as the first directors of the company as per the Articles of Association of the company, all the information regarding them is also required to be filed with the ROC. For instance, their names, addresses, nationality, director identification number, etc. Lastly, as per clause G, the directors of the proposed company are also required to disclose their interest in other companies, firms, or body corporates. So for instance, if the said director is holding shares in another company or is acting as a partner in a partnership firm, then he would be required to disclose such interest in other companies in the prescribed form, which is form MBP1, which is an acronym for Meetings of Boards and its powers. This is also the name of Chapter 12 of the Companies Act 2013, which deals with the powers of the Board of Directors and the manner in which the board meetings of the directors are to be conducted, that we will study in the later videos. Additionally, interest of the directors is also relevant in the context of Section 188, which deals with related party transactions. We are giving you add-on information so that you guys can connect the dots and understand how the provisions of the company law are to be read in tandem to understand the legal framework as well as the purpose and interest of the legislature behind adding and keeping such provisions. As a law student, you need to question the object of every provision, the logic behind its existence, and the purpose served by it. Coming back to clause G, additionally, all such directors are also required to file in another form, which is form DIR2, that they consent to become the directors of the said company. This requirement is to make sure that once appointed as a director, the person doesn't go back on his word that he didn't give his consent to become a director. All this information as per these 7 clauses of Section 7, subsection 1, are in place to ensure transparency and credibility of the people who are incorporating the company and to ensure that the said company is not being incorporated for any fraudulent reasons. Now, let's do a quick recap. We have summarized all the steps of the incorporation of the company in this flowchart. The first step is actually coming from Section 4, that is, reserving the name of the proposed company by filing an e-application, which we had discussed in our previous video. So, once the proposed name is accepted by the ROC, the next steps are in relation to forms, which have to be submitted with the ROC as seen in Section 7, subsection 1. MOA and AOA as per clause A, declaration of statutory compliance by professionals and persons who are engaged in the formation of the company as per clause B, declaration by subscribers to the MOA and directors if named under the AOA as per clause C, information regarding address for correspondence till the time the registered office of the company isn't established, the subscribers to the MOA has to be filed with the ROC, the first directors of the company if appointed under the AOA as per clause D, E and F, and consent of all the persons nominated as directors is also to be submitted with the ROC as per clause G. and the applicable stamp duty as per stamp duty of the relevant state would have to be paid along with the fees as per Companies Act 2013 with the ROC. Pursuant to verification by the ROC of all the documents and information, the ROC would register the company and give the certificate of incorporation that the company stands incorporated as per subsection 2 of section 7. And finally, the declaration must be submitted with the ROC with respect to the address of the registered office of the company. Moving on to subsection 2 of section 7, which says that the registrar, on the basis of documents and information filed under subsection 1, shall register all the documents and information referred to in that subsection in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this act. This means that the ROC will issue a certificate of incorporation, which is an evidence to the fact that proposed company stands incorporated and has complied with all the requirements under the act to get registered. The certificate of incorporation is in form INC 11 and also states the corporate identification number or CIN of the company, which is a unique number to identify the company. We can also find a company using its CIN on the website of MCA and download all the master data of such company by making an account and paying the prescribed amount. MCA charges Rs 100 per hour, and for such duration of time you can download the master data of the company. Now, subsection 3 says the same thing, that the ROC is required to allot the corporate identity number, which shall be a distinct identity for the company, and the same would be included in the certificate of incorporation. To give you an example, we have a certificate of incorporation of a company which was incorporated under section 7, subsection 2 on 4th September 2014 and received its certificate of incorporation by the ROC Chennai, because as we can see, the registered office of the said company is in Tamil Nadu. Furthermore, we can see the CIN or the corporate identification number, which is the unique ID of the company, same as PAN card is an ID for us. We can see CIN is U65992TN 2014 PTC 097200. Even if we only have the CIN of a company, we can get a lot of information about the said company. Let us see how. We can see that the CIN consists of 21 letters. The first letter tells us if it is a listed company or an unlisted company. In this case, it is U, which means it is an unlisted company. Then there are 5 digits, which in this case is 65992, which tells us about the industry in which the company works. The first 2 digits is a code for the main industry in which the company is working, and the last 3 digits is the code for the subcategory in which the company is involved. Then it is followed by the abbreviation of the state in which the company is incorporated, which in this case is TN or Tamil Nadu, followed by the year of incorporation of the company, which in this case is 2014. This is followed by 3 letters, which tells us if the company is a private company or a public company or a one-person company. In this case, it is a private company for which the abbreviation is PTC. For public company, the abbreviation is PLC, and for one-person company, it is OPC. Coming to the last 6 digits, which is 097200, is basically the registration number of the company. So, as we can see, it is quite easy to know a lot about a company just by looking at its corporate identification number. Hit us up in the comment section if you come across any CIN of a company and what all information could you extract from that number. Moving on to subsection 4, which states that the company is responsible for maintaining and preserving the copies of all the documents and information as it had originally filed under subsection 1 of section 7 at its registered office till the time it gets dissolved or wound up under the act. So, till the time the company doesn't get dissolved or wound up, for its entire lifetime, it is required to maintain and preserve at its registered office copies of all the documents and information as it was originally filed by them with the ROC. Now, subsection 5 states that if it is discovered later on that any person had furnished any false or incorrect information or suppressed any material information of which he was aware in any of the documents filed with the registrar in relation to the registration of a company, then he shall be liable for action under section 447 of the Companies Act 2013, where section 447 basically states the punishment for fraud. Moving on to subsection 6, which states a similar punishment that if at any time after the incorporation of the company it is discovered and proved subsequently that the company in question had been incorporated by furnishing any false or incorrect information or representation or by suppressing any material fact or information in any of the documents or declaration filed or made for the incorporation of such company, or by any fraudulent action, then the promoters as well as the persons named as the first directors of the company and the persons making such declaration would be liable for action for fraud under section 447 of the Companies Act 2013. Essentially, the first directors of the company as per the Articles of Association, as well as the promoters and the persons filing the declaration under subsection 1 of section 7 would be liable to be punished for fraud under section 447. It is found after the incorporation if any of the furnished information filed with the LOC was incorrect. Moving on to subsection 7 of section 7, which means to say that where it is discovered that a company was incorporated based on 1. Furnishing incorrect or false information, or 2. By suppressing any material facts or information in any of the documents or declaration filed by such company, or 3. By any other fraudulent action, then the tribunal on an application made to it, if the situation so demands, can give such directions or pass such orders as are given in clauses A, B, C, D and E. Tribunal here means the National Company Law Tribunal, which is a quasi-judicial body adjudicating on matters pertaining to the provisions of Companies Act 2013 and Insolvency and Bankruptcy Code 2016. It was constituted under section 408 of the Companies Act 2013 and is called a quasi-judicial body because it was established under the Companies Act 2013 and it derives its powers from the said legislation. Unlike judicial bodies like Supreme Court and High Court, it can only deal with issues relating to Companies Act 2013 and IBC 2016. Any appeal against any order of the NCLT can be made with the Appellate Tribunal, which is the National Company Law Appellate Tribunal. So, this subsection underlines all the powers that are conferred on the NCLT as to what actions can be taken by it or what orders can be passed by it when any petition is filed alleging that the incorporation of any company was based on incorrect information or by way of any fraudulent actions. As per clause A, the NCLT can pass such orders as it may think fit for regulation of the management of the company, including changes, if any, in its memorandum and articles, in public interest or in the interest of the company, its members and creditors. As per clause B, the NCLT can direct the liability of the members to be unlimited, which means that the members of the company would be unconditionally and absolutely responsible for the payment of all the liabilities and debts of the company, irrespective of the fact that the company may be limited by shares or limited by guarantee, if the NCLT passes an order to that effect. As per clause C, the NCLT may direct the removal of the name of the company from the Register of Companies. As per clause D, the NCLT can pass an order for the winding up of the company, that is, for the company to be dissolved. Or as per clause E, which gives the freedom to the NCLT to pass any such orders as it deems fit. Now, there's a proviso to subsection 7 of section 7 which says that before passing any order, the NCLT is required to give the company in question a reasonable opportunity of being heard in the said matter. And the tribunal shall also take into consideration the transactions entered into by the company, including the obligations, if any, contracted, or payment of any liability. This is based on the rule of law and principles of natural justice based on the Latin maxim, audi alterum partem, which means hear the other side, or in other words, that the other side should be given an opportunity to be heard as well. Thus, no one can be judged without giving them a reasonable and fair opportunity of being heard. Therefore, the proviso is in place so that any company against whom any such allegations of fraud are made is given an opportunity to be heard and to defend itself against the said allegations. Coming to the second proviso, it says that the NCLT will take into consideration the transactions which were entered into by the company, including the obligations, if any, contracted or payment of any liability. So, if the company in question had entered into any transactions with third parties, and if there were any existing obligations of the company towards those third parties with which it might have entered into a contract, then the NCLT would pass the above mentioned orders, keeping in mind that these aspects as well, to see to it that third parties are paid damages or obligations towards them are discharged by the company in question. Now, let's see the definition of registrar, which we came across in this section, which is given under section 2, clause 75 of the Companies Act 2013, which means a registrar, an additional registrar, a joint registrar, a deputy registrar, or an assistant registrar, having the duty of registering companies and discharging various functions under this act. So basically, the Registrar of Companies, or ROC, is an office under the Ministry of Corporate Affairs, which is the body that deals with the administration of companies and limited liability partnerships in India at the state level. At present, 22 ROCs, or Registrar of Companies, are operating in all the major states. However, states like Tamil Nadu and Maharashtra have more than one ROC. There's ROC Pune and ROC Mumbai in Maharashtra, whereas in Tamil Nadu there is ROC Chennai and ROC Coimbatore. The main task of ROC is to register both companies and limited liability partnerships across the states and the union territories. Additionally, ROCs also ensure that both companies as well as limited liability partnerships comply with the legal requirements as given under the Companies Act 2013. Registrar of Companies maintains a registry of records concerning companies which are registered with them and allows the general public in accessing this information on payment of a stipulated fees. The central government preserves administrative control over the ROCs with the help of regional directors, which represent different regions. As of today, there are 7 regional directors supervising the operations of ROCs within their relevant regions. So, in terms of hierarchy, the MCA is the prime executive body, then there's regional director appointed for different regions across the country, and finally, the Registrar of Companies at the state level. We will discuss the regulatory framework relating to Companies Act 2013 in more detail in another video, which will be uploaded soon for better clarity. This brings us to an end to this video. If you have any doubts or queries, feel free to write to us at our Gmail ID, thecaffeinatedcorporatelawyer@gmail.com. Hit us up in the comment section and don't forget to subscribe to our channel if you want to study Companies Act 2013 with us. We'll see you in the next one. Thanks.